Having a hearing is not always the best way to resolve an unfair dismissal claim. Hearings and conferences are formal, legal processes. You have less control over the outcome, and they can cost you a lot of time and effort in preparation and attendance. That's why the Fair Work Commission offers conciliations as the first step in resolving unfair dismissal disputes.
People can negotiate any way they like, and I think because it is informal, it probably does make them feel more able to do that.
This video will explain what a conciliation is and how they are conducted so that you can be prepared to achieve the best possible outcome. A conciliation is not a legal process. It is more like a meeting but is conducted in a telephone conference call. The conciliator is an independent, impartial person who runs the conversation between the employee and the employer. They're a bit like an umpire who ensures fair play. The point of the conciliation is to see if both sides can come to an agreed settlement without needing to go to a conference or hearing. You are under no obligation to settle if you don't want to. It is your right to maintain your position and proceed to a hearing. Conciliations are confidential. You shouldn't disclose things that are said by other people in the conciliation. While you can choose not to participate, it is in your interests to give it a try, as most cases do settle at this stage.
I understand it's 4 out of 5 overall at conciliation, either on the day of conciliation or perhaps a couple of days after, because we do give people the opportunity, if they're unrepresented, to think about offers and counter-offers and also get some advice if they wish to.
In a conference or hearing, the possible outcomes are very limited and strictly controlled by the law. But conciliations give you a lot of flexibility in what outcomes you can achieve. In a conciliation, absolutely any outcome is possible, provided both parties agree to it.
Often at conciliation, resignation at the date of termination is negotiated, and a statement of service, sometimes a reference, an employment separation certificate for Centrelink, often that hasn't been provided, a final pay slip, for instance.
So, this is how a conciliation works. The conciliator runs it by phone from their office. Everyone involved has the employee's application and employer's response, so everyone knows what each side is arguing. However, it's not the conciliator's job to try to judge those arguments. That only happens at a conference or hearing. The conciliator is there to explore whether an agreed settlement can be reached between both sides. First, they get the employee, the employer, and any representatives or support people all on the same telephone conference call.
Natalie, are you there?
Hello, this is Natalie.
And John, I've got you now.
Morning, John speaking.
I've got you together, thank you.
This conference call can take up to 1.5 hours. It's important that you set aside that time in a quiet place where you have privacy and won't be disturbed. Employers are usually in their office or business, while employees will often take the call from home.
He just told me that I wasn't up to scratch and basically said pack up your stuff and get out.
Each side gets to put their position to the other. Often, this can be the first time the parties have really spoken about the dismissal.
She came in late all the time and went home early and had too long a lunch break, so I just had to let her go in the end.
Often, people are apprehensive about these discussions, but the conciliator is there to ensure they remain polite and on topic.
We listen to both sides. We are not in a decision-making role. We're not in the role of hearing evidence or determining evidence. And where there are disputes on the facts, we just say, look, these are disputes on the facts. And Natalie, I'll have the private session with you now. If that's okay with both of you, John, could you hang up? So Natalie, I'd like to ask you what you'd like to say, and I'd like to ask you also what you hope to achieve out of today.
What I'd like to get is my job back, but if that can't happen, I guess we can negotiate some compensation.
Both sides need to come to the conciliation with a clear idea of the outcomes they want to achieve or are prepared to accept.
Thanks, Natalie. So I'm going to ask you to hang up, and I'm going to speak to John, have the private conversation with him, put your offer at the end of that, then get his response, and then call you back after that.
Good morning, John speaking.
So John, I'm coming now to what Natalie is actually seeking out of the application to settle the matter.
The conciliator explains what the other side wants and asks if it is acceptable.
No, I can't accept that offer, but I will be able to offer you perhaps 2 weeks' salary.
Eventually, everyone comes back together after the conciliator has relayed the offers and counter-offers between the parties. If a settlement has been reached, it will usually be set out in a written agreement which both parties will sign. Unrepresented parties are offered a 3-day cooling-off period to decide if they wish to opt out of any agreement. If no agreement can be reached, the conciliation stage is over and the matter proceeds to a conference or hearing.
It's the role of the conciliator to refer the matter to arbitration, to refer the matter to the team which deals with that stage, to obtain written submissions and witness statements.
We have a separate video on conferences and hearings that tells you how those processes work.